Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome everyone to Aging Insight. I'm Lisa Schollmeyer. I'm here with John Ross, and we're elder law attorneys, and we bring you Aging Insight so we can educate you and provide you some information about many of the different things that you as a senior adult, or maybe you as a family member who's caring for a senior adult, information that you need to just navigate through life. So we're coming to you on Aging Insight like we do every week. So we appreciate you sticking with us.
That's right. And we bring this program primarily to talk about lots of different things that go through the aging process. And of course, one of the natural conclusion to the aging process is dealing with death and the aftermath there. And we get a lot of calls, we get a lot of questions about what to do after somebody has died, probating wills or transferring property and dealing with that sort of thing. Most often, I would say, those conversations are families who are getting along. They're just trying to figure out what to do.
Right.
It's a tough situation. There's a lot of sadness, but otherwise they're just trying to get through the process.
Right, and that is the vast majority of the situations that we see are families that do get along and everybody is moving through this process. But John, there are a few families that's not the situation.
Right, and that's where you start getting some of the contention in the family, particularly when it starts when you start talking about transferring of assets and dealing with that sort of thing. And in many cases that can culminate in a will contest.
Right, so often, many folks understand that when someone dies, they may have left behind a last will and testament. And of course, a last will and testament is a document that states what the decedent, the person who's died, what they want to happen to their property, who they want their property to go to following their death. And a last will is simply a piece of paper that lets those wishes be known, but in order for those wishes to be turned into legally enforceable provisions so that the beneficiaries will ultimately receive that property, you have to go through a process called probate. And this is where the last will and testament of the deceased is brought to the courthouse through a certain procedure and an application to probate the will, and ultimately a judge reviews the will to make sure it is executed properly with the proper formalities, and the court takes evidence that at the time the will was made that the deceased person had the capacity to make a will and knew what he was doing. And so you have that probate process that's involved. And John, because that's the process that effectively passes assets, that is where a lot of times that conflict comes up.
Right, and generally this is going to be in a situation where somebody is unhappy with the outcome. I would say probably the more often we see this in blended family situations where you have, for example, a surviving spouse who is not the parent of the deceased person's children, or in a blended family situation where the brothers and sisters are not themselves necessarily related to each other. Maybe mom and dad both had children from prior marriages. They were married for a long, long time. And so the kids were raised almost as brothers and sisters, and yet they're not, and so there can be conflict. The other way we see this is oftentimes in disproportionate distribution situations where the parent has died and they have left things unequally, and some particular child is unhappy about this. And so there's lots of different ways this can pop up, and particularly when you're talking about a will. Again, the first thing that has to happen for that will to be valid is it's got to go through that probate process. And because this is a court process, this gives an opportunity for anybody who is unhappy with what that will says. This gives them an opportunity to come in and make their complaint and voice their reasons for why they think maybe that will should not be the deciding factor on how assets are distributed.
Right. So John, basically we're talking about will contests today, and I thought while we would provide some information generally about will contests, I would say that the vast majority of will contests are not successful. You agree with that?
I would definitely agree with that. It's very difficult in many cases if you have a well-prepared will, and by that I mean something that's drawn up by an experienced estate planning type attorney. That's going to be very difficult to challenge. Now, that being said, I have seen many do-it-yourself ones that were invalid wills on their face.
Right.
And
right.
those were actually very easy to challenge. They didn't have the minimum requirements, like they weren't witnessed or something like that.
Yeah, and so while today we're not really going to get into all the details of what it takes to be a properly executed will, but we did want to talk about the process of the will contest, and particularly maybe if you're the executor of the will, how you would go about defending the will that you are the executor for from a will contest. And so I guess we'll take a break and we'll come back and talk about how to defend a will in a will contest. Stick around.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm John Ross here with Lisa Scholbeyer, and today we're talking about will contests, and in particular, if you're the person who is you're the one that's proffering that will. You've got the will, you want to make it official, you want to follow the testator, that's the person who made a will. If you're trying to follow the testator's wishes and somebody is unhappy about it, how best do you go about defending that will? That's kind of our topic for today.
Yeah. And so, John, as the executor, I guess the first question is, how are you made aware that someone is unhappy officially?
Right.
You may know they're unhappy unofficially.
That's right, because a lot of times, and I will get these calls from clients that we're helping through the probate process, and they'll say, well, my brother, my sister, my whoever is contesting this will, or they've said they're going to contest the will. And what they've said is they're unhappy about it, but they haven't actually gone so far as to go through the legal process. Generally, when you're contesting a will, either before the will is admitted to probate or after the will has been admitted to probate, something is going to get filed in the court saying this will is not valid for these reasons. A complaint, a challenge, and typically that's something that's going to be done typically via an attorney. It is possible for people to appear pro se to to challenge a will, but generally that's unlikely because the probate process is very, very complicated, and even many experienced attorneys avoid probate and leave that to the experts in elder law because it really is much different than other forms of law. So yeah, I've talked to many of those family members and I've said, well, right now what you have is an unhappy beneficiary. You don't have somebody who's actually contesting it yet, because the contest starts when they file something in the court. And you know, Lisa, when somebody files something in the court, I mentioned that it's either before the will is admitted or after. And when I say admitted, that's when the judge says, yes, this is an official will. And you can challenge that before that happens, and you can challenge it after that happens.
Right.
But there's kind of a difference between those two.
Right. You know, if the challenge is entered against the will before the judge has seen the will, before the judge has offered his opinion, and by the way, a judge's opinion is really the only opinion that matters.
That's right.
But if a challenge to the will is offered before the judge has rendered his opinion about the legitimacy of the will, well, that puts the burden of proof on the executor to prove that the will is valid, that it was executed properly, that the testator had the proper testamentary capacity. But John, there's a big difference that if a judge has already seen the will and has already signed off and on their opinion said the will is valid.
That's right.
That is called admitting the will to probate. I think that can be a very confusing term for people, but it's admitting the will to probate is just when the judge signs off and says it's a good and valid will. But if someone complains about the will after the will has been admitted to probate and the judge has signed off, well, that changes what kind of evidence.
Right. There's a period of time, which can be as long as 2 years, following when the judge says, yes, this is a valid will, that somebody else could come in and say, no, it's not. But if somebody else comes in and says, no, it's not, then it's that person, it's the complainant who has the burden to try to prove why that will is not valid. So that's a big difference if you're the executor, if you're the proponent of the will. You're the one that wants to follow the will. If you can get that thing admitted to probate first, then it's going to be much more difficult for other people to prove that what you've already done is wrong. As opposed to, if they challenge you in the front, then you've got to prove that what you want to do is right.
Yeah, so I guess the first tip for any potential executors out there is, you know, when someone passes away and you're going to be in charge of the estate, and you know, check with an attorney, see if you've need to probate that will, and if the answer is yes, then go ahead and get that process started, because the sooner you have the judge's approval on that will, the better off you are. So I guess tip number one.
Yeah, tip number one. Now, if you anticipate that somebody is going to be challenging this, or somebody has already challenged it, the next point is going to be gathering up your evidence, essentially. What are the factors here that are going to prove all of this? And really, probably the most important person in dealing with that will, as far as evidence, is going to be the attorney who prepared the will and supervised its execution.
And you know, John, that assumes again that it was a will prepared by an attorney.
That's right.
You know, in Texas, it's in Arkansas, and in most states, there's no requirement that an attorney prepare the will. But this is a good point, another good reason to have an attorney do so, because if an attorney prepares a will for a person, they are going to defend that will, and they're going to help you defend that will as being a valid will.
Well, and if you think about it from the standpoint of, put yourself in the attorney's shoes. You know, if I've drafted a will for somebody, then that means I've met with them, I've talked to them, I've had a conversation about what they want, and I've probably met with them on more than one occasion. The first meeting to talk about what they want, the second meeting maybe to go over an initial draft of that will with them and see if what I put on paper is what they wanted. possibly even a third appointment to make some changes or some corrections on all of that. And during all of this process, I, as the attorney, am going to be learning about them. I'm going to be hearing them speak about their person, their estate, their family, their wishes, their desires. And from all of that, I'm going to have a pretty good idea of whether or not they understood what they were doing, whether I got any indication that they were being pressured to do it by somebody else, or if there were any other weird circumstances going on. And you know, as elder law attorneys, we won't do a will for somebody if we recognize those issues.
Right, and you know, the attorney is an ethical attorney is always going to be meeting personally with the person who's making the will. So that attorney, if you find yourself as an executor with a will that is being contested, then if it's an attorney prepared will, the very first thing to do is to reach out to that attorney who prepared the will, to prepare them that the will that the attorney drafted and executed is being contested. So, and also to let them know to preserve their file, to, you know, perhaps review their notes, and to be prepared and ready to come to court to offer testimony about the validity of the will.
Right, but notice you didn't say go to that attorney and hire them to fight for you.
No, I did not, because in this particular case, the attorney who drafted the will and assisted the testator in doing that will, that attorney is a fact witness to the circumstances. And under the ethics rules and rules that govern attorneys, an attorney who is a fact witness cannot also act as an attorney advocate for either of the parties in the case. So in that case, John, they need to call the attorney that prepared the will, let them know they're a witness, but they're going to have to hire another attorney to actually defend them in the court proceeding.
That's right. You know, in an uncontested, I've certainly handled lots of uncontested probates that were the probate of a will that I drafted. But there was no contention there. There have also been cases where a will was being offered for probate that was being contested. It was one that I have drafted, and that was not a case that I could be involved in because I knew I was going to be a witness in the deal.
Right. So we've got a couple of more points for you. If you are the executor of a will and you find out that there's some beneficiaries that are unhappy and they're going to contest that will. So when we come back to our last segment, we'll finish up giving you some tips on how to defend your position and the will. Be right back.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic could do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight. Today we're talking about defending a will in a will contest. And the first point we had was, if you're the executor of a will, get that will offered for probate and take care of your business as soon as you know that that's the direction you need to go. Second tip is, if you know the will that you are the executor for is being contested, then reach out to the attorney who prepared the will to assist you with making sure that your facts are in order. And John, that kind of brings us to the third point of some other important people that you're going to need to track down.
Well, the beauty of people that at least based on my experience, and you and I have both been through lots and lots of will contests.
Yes.
And my experience is that people who are unhappy with wills, they do one thing, and that is run their mouth.
That's true.
And so often they're going to have told you and everybody why they think that will is invalid. that either the person who made the will lacked testamentary capacity. In other words, maybe because they had Alzheimer's, or maybe because they were on medication or something like that. Or the other way is to challenge it based on what's called undue influence, that they were pressured to do it, that somebody was twisting their arm essentially and saying, do this or I'm not going to care for you, or do this or you're never going to see your grandkids, or something like that, some way that they were influenced into doing it. And so you're usually going to know these sort of things in advance. And so there's going to be other people here that you're going to, not just the attorney that drafted all of this, but some other folks that you're going to want to get involved to be able to refute those type of claims.
Right. For instance, the witnesses in Texas, it is in Arkansas, and most every state, you have to have witnesses to a typewritten will. So the witnesses are in the room at the same time the testator is signing, and usually there's some conversation. There might be some small talk and discussion about the will and the making of the will. So those witnesses are important people to be able to testify that the testator was thinking clearly and appeared to be competent, and nobody was twisting their arm or giving them the evil eye across the table. And so those witnesses are important. Also, medical people who may have been treating the testator at the time they made the will are important people to know who they are and to contact. John, I had a will contest one time where a lady, she was on hospice care. She had suffered from cancer, and she knew her time was limited, and she decided to change her will. And she actually had the hospice medical director come in and do a little capacity examination and document that in the medical records, because she knew that her changes were going to make somebody unhappy.
Right.
And so she knew there was likely to be a contest. And in that case, the testator themselves actually helped the record show that she was competent and knew what she was doing. But and later on, the testator was exactly right. There was a will contest, and we were able to use those medical records and reach out to that medical person to offer evidence about the capacity of the testator. So
well, and similarly, there was a case in East Texas. The contestant was claiming that the person was unduly influenced, that they were being pressured into doing it. And when it came down to the fact that when that person executed the will, they were in a room with nobody else but the attorney and the two witnesses. And the court made the point that this person had that opportunity in that room all by themselves they could say and do whatever they wanted at that moment. And so there's no way that somebody could have influenced them, even if they influenced them before they walked through that door. Once they were in that room, there was no more pressure for them to do anything other than what they wanted to do. And so again, that's where those witnesses came in that said, we talked to her. She said this is what she wanted to do. There was nobody else around. There was nobody pressuring her, nobody holding a gun to her head. Mm-hmm. And so there you go.
Right. So, and I will tell you, and John and I often say, if you're at the courthouse arguing about something, in many ways, you've really already lost, in the sense just of the time and the aggravation and the funds that are spent on lawyers and the process. So it comes down to, we should like to avoid will contest if at all possible by doing all the things that you can do to do proper documents to where there's no real question about them. Maybe even to look at will alternatives such as trust, which are much less likely to be contested. So there's a lot of things you can do, but many clients have found themselves in the position of defending a will. So we thought we'd offer a few tips today, even though we hope that you never find yourself there.
That's right. Gather up your witnesses, gather up your evidence, and get some good advice. And of course, that's why we do this program, every week on Aging Insight is to make sure you have good advice out there on all of these sort of issues. If you want some more advice, you can always listen to our radio program on 98.7 FM right here in Texarkana, and also on 740 AM. And we're there live every Saturday at noon, and you can call in and ask questions. You can also pick up a copy of our Aging Insight magazine, which has got lots of good articles on Medicaid eligibility, veterans benefits, powers of attorney, guardianships, all of the stuff that you hear right here on this program. You can also go to aginginsight.com and you can pick up past episodes, watch some of the old ones. You can listen to the radio programs live online. You can even read transcripts of all of these programs in case you need to take some notes. So lots of ways to get good information out there.
So we are looking forward to being back with you next week with some more information here on Aging Insight. Thanks for your time.
See you next time.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by